happy to be here. Very happy to be here. And thanks. I want to start by thanking Professor Nausica Palazzo for the invitation. And of course, congratulate her and also Jeffrey Redding for this very beautiful and very interesting book that is launched here today. I'm not going to talk a lot, and I'm not going to talk about the topic, as of course I'm not an expert on the topic, although I'm pretty curious about it. But what I would like to say, just to do a brief introduction, what is our school is, just for the ones that are visiting us, and even for the others that are here with us today, and how what we are or we want to be and we already are is matches in some way this book and this event here today. So Nova School of Law was founded in 1997, so it has 25 years, so it's very young school, and was founded based on innovation. So the idea was to have a school in Portugal, a public university that was different from what was being done at the time in Portugal when teaching of the law. So innovation is one of our core features. And again, this topic and all the topics that are topics of the present and haven't been addressed properly, or at least in a traditional way, are topics that are interesting for us and interest us at our school as school. Also, pluridisciplinarity, I'm pretty sure that the topic and the way it is addressed is not a very legal, dogmatic one, or only from the point of view of the law, but the law in context and the law from different perspectives. Moreover, we picture ourselves as an international school, as I was just saying here to Professor by my side. We picture ourselves or want to be a school that it is in Portugal, but it is international at core. So we have lots of colleagues that are not Portuguese, starting with Nausica, for instance, that came from different parts of the world. And I think this is something that it's really a privilege for our students that in the bachelor degrees essentially most of them are Portuguese, to be able to have different professors from different with different backgrounds and different understandings of the law and different experience, to be able to open their minds and make them more not only knowledgeable but critics, and have this ability to think differently and look at the same phenomenon from different perspectives. And finally, the concern that we have with the big questions of the present and the future, not only with what we refer normally to digital transformation and things like sustainability, but also things that regards equality, regards the dignity of humankind, of every human being. And this is something very important, that all of our students leave our school with these speakers that are missing. Yes, okay, yes. So maybe we can just wait for them to have a seat. Here. Yeah. Hey, the royal seat for you. Thank you. Today too. So just saying that, just to finalize my very brief speech, to say that every problem has to be tackled based on the respect by humankind and human beings. So this is the center of any law school, at least as I see the law. It's the respect for human dignity and respect for everyone, as maybe each one of us is different. And so we have to respect everyone in the same way. And any issue and any problem of today, tomorrow, the future, the past has to be addressed based on this assumption and this respect for humankind and human beings. And this is something that we also, I hope, all of our students that graduate from our school have embedded in their hearts and in their minds. So again, this is another reason why I'm so happy to be here to participate in the launch of this book and congratulate again the authors for this amazing job they did here. Thank you.
Thank you very much, everyone, for being here. I have actually a very long list of acknowledgements, so I'll try to be quick. Thank you, Mariana. Thank you, Nova School of Law. Thank you to these wonderful authors for making this possible. Thank you to my students here at the comparative law course, family law course that are really wonderful. I want to go straight to the point. Yesterday, I was asked, what is this about? Are there alliances between queer groups and religious groups? Why does this matter in the first place? And I want to share the answer that I had to give to this friend of mine. And it's basically, we do not have alliances between queer and religious groups, right? We do have this very common narrative that frames them as, right, opposite factions that do not talk to each other, that actually do hate each other. So what are we doing here is simply to sort of look through the cracks of this narrative, look to see if there is loopholes, if there is gaps, if this narrative is failing to see something that is happening in the other world. Why? Because it might actually help us overcome this very, very bad corrosive narrative that, again, depicts these two groups as opposite groups. And we are looking at the United States, we're seeing what's happening in the United States these days, how this oppositional frame is not doing a good work, it's not doing a good service to many vulnerable persons and groups. So what are we doing is to sort of see if there is a different narrative out there. And we think that there is. First of all, I will give an example. Some authors in our book, such as Frederick Geddes from Brigham Young University, are noticing that, for instance, Mormon communities that were practicing polygamy in the 19th century have suffered from the same natural law arguments, right, than LGBTQ couples in the context of marriage equality. So both of them have suffered from this idea of family as something immutable, transcendent, natural. This is what it is, and no one can have a say about what else can it be. So that's an example. Another example being a nice chapter, a very beautiful chapter from Federica Guzmano, a sociologist from Italy, who looks at friendships, platonic relationships, to see how both, of course, this is a queer project in the sense that queer groups have an interest in overcoming the idea of the sexual family. So this idea, especially important for us as lawyers, that we should give legal benefits only if the family has a sexual component. So in this sense, it's clear that this is a queer project, but on the other side, she sort of reflects, she thinks if this could also be a religious project. Right? If we think about these religious groups such as Catholic denominations that have values of charity, right? And the limits of this project. And I also look at some laws in North America, such as Alberta, Vermont, but also Australia, that were pushed forward by religious conservatives, but that were actually recognizing friends and relatives for the wrong motives, for very, very weird motives, of course. But we do need to look at these experiences to understand if there is something that they can teach us for both the contemporary moment and for future alliance. So I think that this book is a very brave, attempt. And I want to thank a lot the authors for engaging in such a brave attempt at rethinking radically, critically family law politics. And by radically, I mean really radically, because some people in this crowd, they were talking about it, are thinking about very innovative ways or of organizing these family relationships, such as legal pluralism. Legal pluralism, for instance, in Israel, is seen as personal laws given to different religious groups, Jewish people, Muslim people. What about applying the same theoretical framework to LGBTQ couples and religious groups, right? Or even thinking about new ways of institutional competition between religious institutions and secular institutions. And this is Laura, excellent work. Again, there are many problems potentially with this narrative. So I want to say that this is a work in progress. And I want to say, not because I want to insulate myself from criticism, but because I encourage you to advance your criticism, your doubts, because we want to have this uncomfortable conversation, but still a necessary conversation in my view. So I will give the floor to my wonderful co-author and co-editor, which I will not be able to thank enough for all the work, literally, that he put night and day into this book. Jeffrey Redding, the floor is yours.
Okay, thank you so much. So I also similarly want to thank the authors, because this is a difficult subject in a difficult time. And I do think brave is the right word to describe many of the contributions. And I also very much want to thank Nausica for inviting me into this project. So Nausica originated the idea and did so much organizing around the original conference, which people contributed to. And I only came into this project later. So friends asked me, why are you interested in this? And so I thought I would just kind of briefly tell you why I, as a comparative legal scholar, am interested in queer and religious alliances, and then use that as a lead-in to talk about the geographical scope of the present project, and also how we might move it or consider moving it into other jurisdictions. And then think very briefly and very sketchily about other potential queer religious issues or alliances that are not discussed in this book, but maybe in the next book. So why am I interested in this as a comparativist? So most of my previous work has been in South Asia, India, and Pakistan, and in both jurisdictions, but particularly in India, I have done a lot of research on what's called the personal law system, which is a familiar system to people in Israel and many other places around the world. But for people who are not familiar with personal law, broadly speaking, is a system of religiously differentiated family laws. So in India, for example, there is a Muslim personal law, there is a Hindu personal law, there is a Christian personal law, there is a Zoroastrian personal law, and there also historically was a jurisprudence on Jewish family law too. So personal law systems in India, the existence of this pluralistic family law system, pluralistic, religiously kind of defined family law system, it's really come under a lot of criticism by both feminists on the left in India and Hindu nationalists on the right in India. Now, minority voices, particularly Muslim, Christian, and to a different extent, Zoroastrian, they have embraced the personal law system and have resisted efforts to introduce what's called a uniform civil code or a uniform family law system in India. And minorities have used arguments related to community self-direction, community sovereignty, and community agency to say, this is law that we kind of own in a way. It's our law, and we don't believe that we should have to participate in the system where we're not going to have that same kind of control, authorship, and agency vis-a-vis the law. So this is my kind of personal background. And then I was writing on these issues, researching these issues when the whole same-sex marriage debate in the United States was going on. And it wasn't that long ago, but during that time, if you remember, right, there was highly variegated family law across the United States. There was no Obergefell decision constitutionalizing same-sex marriage rights across the United States. So every state had a different family law system, and within, so you had a kind of personal law system in the United States at that point in time, but you also had a personal law system in an even deeper way, or at least along another dimension, in that there was, in many states, one family law for heterosexual couples and another family law for homosexual or same-sex couples. So obviously this system faced a lot of, this American personal law system faced a lot of criticism by people, by feminists on the left, Lgbt activists, and moving forward, I think this system, if Obergefell is overturned, if we return to this personal law system, the action may not stop there, right? There may be efforts on the right to kind of move towards a uniform system of not allowing same-sex marriage rights. So, thinking about the arguments that were used on the left against this American personal law system, they often related to dignity, saying that, same-sex dignity or gay dignity was compromised by this American personal law system. And I wrote a couple of pieces challenging how dignity was being understood, and saying that there's actually potential and real possibilities here for gay people in at least some parts of the United States in authoring this same-sex personal law system that was being put on them. But if it was seen as less of an imposition and an opportunity, perhaps we could have gay personal law, like gay author, gay controlled, gay sovereign personal law in the United States. So that's that's kind of an initial foray into thinking about the religious and sexual dynamics that were really complicated, and the possibility of both religious and sexual and personal law. Now, I'll be brief. I think we don't cover India directly in this book, but there's a lot of ways in which this book's discussions are gesturing at discussions in a large number of jurisdictions that are not explicitly discussed. So let me just quickly say that now same-sex marriage is a big topic of discussion in India, and there's litigation going on in multiple courts trying to get a constitutional right to same-sex marriage, but there's tension between different groups and different advocates about how this should happen within India's personal law system. So some people say that the Civil Special Marriages Act, which is I think the members of all just states, that a same-sex marriage right should be more firmly embedded or recognized within the Civil Special Marriages Act. Some people have said a new act altogether, something like a same-sex marriage act, thinking about, again, gay personal law. And then others are saying, well, we should, not do either of those and push for reform within each of the religious communities and within each of the religious personal laws. So have, advocacy within Muslim communities, advocacy within Hindu communities, advocacy within Christian communities. So this is, I think, like an area, a future area where there's going to have to be a lot of discussion between queer people and religious people, and where this is a very mobile discussion where both are going to contribute to the discussion, but I think also really be shaped by the discussion. I'll end by just saying there's a lot of other issues, not only jurisdictions, but issues where I think this book's current discussions might lead us. So I mean, this is very controversial, but I'll just throw it out there. Gay conversion laws in the United States. So there's been a lot of legislative activity recently saying that these gay conversion camps and gay conversion programs that are run by different religious groups, that these are child abuse, they are psychologically coercive, psychologically damaging, and these gay conversion programs should not be allowed. Well, okay, but there's also been parallel efforts in other democracies like India to control religious conversion, to say that religious conversion is coercive, it takes advantage of people's vulnerabilities, their material vulnerabilities. And so I think there is something here in which there could be further discussion about what is the queer position on the source of sexuality, its immutability, its relationship to other mutable characteristics like religion, assuming religion is mutable, and maybe it is not. And then I think finally, I'll just end by saying that with abortion access, I think that the underlying set of discussions in this book about pluralism are going to come back on the table. So as challenging as the Dobbs decision has been to read, it does return, at some level, it just is simply, I hate to use that word, but it simply returns the US to a regime of radical pluralism. And this is, not where same-sex marriage is, for example, in the United States right now, but it's where it very likely would have been. Let's just remember that it was a 5-1 decision. And it may be where we move shortly. And I think this book's fundamental questions about the relationship of pluralism to queer and religious politics is really central to these emerging developments in the United States, India, and elsewhere. So I'll just end. Thank you.
Can she open it?
Okay. 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 So we're just taking the 30 seconds because we need to go over the audience. Oh, okay. I'm on the next. It's your go. Yeah, perfect. So let's try to buy 30 seconds. Easiest for you here. And as you prefer, yeah, we have it there. We have the PowerPoint, right? Okay, excellent, fantastic. Okay, so next is Robin Frederickson. Robin is the director of the Institute of Government and Public Affairs at the University of Illinois College of Law, the Milton Van Boris Jones Law, if I pronounce it correctly, and many, many more things. Thank you very much for being with us.
So thank you. Can you hear me at the back? Okay, perfect. Then I won't use a microphone. So I'm going to tell a story that actually picks up where Jeff and Nausica left off. And it begins with same-sex marriage. And I'm going to describe some blowback that conservatives had around same-sex marriage. And why I think the kind of menu of options that they were hoping for, kind of radical pluralism, to use Jeff's term, would have been very short-sighted in their own terms, and something that they should and could and were in fact talked out of doing. And then I want to come forward, so I'll make a case about why we want to keep marriage, both the civil and the religious aspects of marriage in the United States together, because unwinding them and adding something radical to the menu would actually be very difficult because of the way our 50 states recognize relationships as you move among them. And then I'm going to come forward to Dobbs, which I already see Jeff is here with us on. And in particular, something I said publicly in Washington, DC around legislation that would blend LGBT rights with religious liberty, an actual alliance or melding of rights, what I call civil rights complementarity. But a criticism that I had of Justice Thomas for raising this specter that somehow we are going to roll back same-sex marriage. So I'll just cut to that point very quickly. He is out of mind. We are not going to do this, and I will show you why. Okay, so let me start there. How do I click or advance?
You have
You do this and then
I do this. Okay.
It's
I've
immaculate.
never felt, and I just want to say, for those in the room, I brought my fan, so I could do this, you know. I had a little less than a fan, so we'll go forward. Can you put that on the biggest slide screen? So if you pick the little one that projects the whole thing.
Yeah.
I can help, I'm sorry. Give us 1 second, we'll make it bigger, because you'll need that in a second. Excellent. Okay, so this story starts in 2015. And I really want to applaud Jeff and Nausica both for talking about ways in which we need the LGBT community and the religious community to work together, because they make parallel claims on society. LGBT people want to be fully themselves in public and in private. And so do religious people. And sometimes these rights bump up against each other, not because they're inherently in tension, but because we have old laws that we try to ratchet modern debates through. And so those laws need to be changed, okay? As we're writing new laws, like same-sex marriage, for example, you will see religious liberty protections in the United States put in all 10 of those state laws before we got to Obergefell, and in the District of Columbia, thoroughly blue states, writing religious liberty protections and making it possible for the legislature to enact same-sex marriage. That ultimately will influence in 2015 the US Supreme Court, I believe, to actually, recognize the constitutional right to same-sex marriage in Obergefell. Now, also in 2015 is something that I participated in, and it was interesting to. Is Rick also presenting today? Sorry, is Rick going to be presenting by Zoom? Fred Geddix, I'm sorry.
No, it's not.
But this is something that was done in Utah. It's called the Utah Compromise. I worked with the legislature as this thoroughly politically conservative body, literally at the time, the single most conservative legislature in America, enacted protections in housing and hiring discrimination for the full LGBT community under 14, including the entire trans community. They gave in that law more rights to the full LGBT community than that community had in state law in New York expressly at the time. So these alliances can not only happen, they can bring forward profound change. Okay, so the context that I did this chapter, or the work for this chapter in, was there, helping these folks think about how do you blend protections for religious people with protections for the full LGBT community in the same law. And at that moment, even before, if you'll go back, can you go back to the front? Even before Rand Paul and all of these conservative lawmakers after Obergefell start screaming, we need to get the government out of marriage. Why are they saying that? Because they lost, right? They're saying, oh, suddenly the government needs to be out of marriage, we lost, okay? Even before that happened, if you come forward for a second, in the context of the Utah Compromise, in the space of 45 days, 27 Republican senators and nearly the entire Republican House had to be convinced that they should rewrite their own anti-discrimination. And in the course of that, if you come back down to the next slide, there, I had a conversation with a gentleman who at the time was a Senate president, Rolf Ullrich. And I'm sitting at a table with him and I'm saying, sir, you can take these rights for religious people and these rights for gay people and just put them together like this, like a puzzle, and you're writing those laws and we can make them work. But it's complicated. And how many of you are spending time with any US lawmakers? Maybe Jeff, okay. So is this being recorded?
Yeah.
Okay. I say nothing more, but it can be complicated. We're law professors, okay? We have the luxury of studying something. I had the luxury of helping legislatures write same-sex marriage laws for a decade before these people started on this project. So it can be a lot to take in a very short amount of time. And so Senator Oberlin says to me, no, Robin, this is too hard. We should just not do this. Why don't we just take the government out of marriage. And he literally says that long before Rand Paul says those words. And I said, that's like this cup of water, which I actually had on my desk sitting there talking to him. And I said, it's like trying to turn over the cup of water and have the ice come out and the water stay in. It's not going to go that way. The entire thing is going to be sort of unleashed. And so you don't want to do this. Far better to write real laws where you try to figure out how real people are going to live together in a way that allows all of them to flourish. Do that work. It's hard work, but you can't turn upside down the cup and hope that this works. Now, why is that in the United States? You'll go forward for a second. Oh, let me go back to where we were in Obergefell for a second. So lots of things were said in Obergefell, not least of which is the Chief Justice actually dissents in Obergefell. It was the only dissent in 10 years during his tenure at that time that he read from the bench. It meant that he cared deeply about it. And he says, you know, people of faith can find no comfort at the bottom here in the treatment that they receive today. And there are all these questions about tax exemption, some of them real, by the way, and do need to be solved in laws around same-sex marriage. But then come forward for just a moment. It takes about a hot minute after Obergefell to get to our favorite convict. This will not be a person that you recognize, but in the United States is a woman named Kim Davis, who immediately out of the box says to this very nice couple in Kentucky who wants nothing more than to marry because they've been given the right to do so. She says, no, you should wait over a year. And doesn't serve them for weeks. Now, Kentucky has since had to settle this case and pay the ACLU something like $225,000. Didn't go well for Kentucky, okay? But her claim was that her conscience allowed her to strip other people of a constitutional right. Now, when you're meshing puzzle pieces and rights together like this, one party doesn't get to take rights out of the other party's basket. It's not how it works. You do want to find a way where you can keep all those people well. Okay, many people in the United States at the moment of Obergefell did not believe in Obergefell. Some of them worked for the government, some of them were judges, some of them were bakers, the Masterpiece Cake Shop. We do need a way to leave those people to the side. A lot of progress in life comes from leaving people to the side and making forward with the rest. And that's a kind of way of writing these things, these laws together. We can talk about that, but that's not the subject of this chapter. This chapter then says, what do you do with the next guy, the governor at the time of Kentucky, Matt Bevin, and many more lawmakers I will show you in a moment, who start saying, what? Oh, get the government out of marriage because we've lost and we want the government out. Okay, go forward. You'll see that that trope, I actually discovered a new way to look at like media and something called Harvard Crimson. But you can see that long before we even get to Obergefell, every single time there was a massive win for same-sex marriage, you started people hearing saying, get the government out of marriage, get the government out of marriage. So it was there in the background. That's where Ralph Oakland was getting it from. Okay, and I hadn't actually been very tuned into it until I was talking to the senator. Okay, so now you go forward. As soon as you get past Obergefell, people actually start writing proposals like this, and they look very different depending on what state you're in. I picked two, Missouri. So Missouri's like, yeah, we're not going to recognize stuff anymore called marriage. And we would recognize domestic unions. It would be the same for straight or gay, you know, so that's good. And marriage would be an exclusively religious institution with no legal effect. And the real problem will be, how do we go from where we are to that? And his bill doesn't really talk about that, you know, because that would be hard. Instead, he's just like, yeah, that's what we're going to do. Okay, then go to Indiana. Notice, by the way, all these people are ringing around in Illinois, which is interesting right now in the middle of Dobbs, because we're going to become an oasis, a destination for abortion in the Midwest, precisely because of some of the same impulses of people, okay? So this guy is Jim Lucas. Jim Lucas actually had a very weirdly progressive liberal idea that had come from feminists. which was, oh, marriage, we don't need marriage as an institution, we'll just have contract, right? Where have you heard that before? Like Martha Feynman, okay? So very deep conservatives now copying, you know, feminists, but in any event, I'm not sure they realize that. And they want everybody to write contracts with each other, and those contracts would have public policy limitations around them, which, you know, would do things like say, well, you couldn't waive a right to child support. Okay, I would hope not. But then don't answer other things like, should a woman who invests all of her life in a relationship be left with nothing at the end? Right? Domestic law for families and marriages speak to this question. And he wants people to bargain for it. You know, I mean, okay, well, anyway, back to the topic. So if you go on, in the United States, we have a wrinkle that's different than Israel. So every religious marriage in the United States has civil effect. You cannot have a religious marriage without a civil effect. You can have a civil marriage without religion, true, but you cannot have a religious marriage without civil effect. And it's so deeply bound up in the United States that when there is a religious marriage, it brings the civil marriage into existence. You don't even have to go to the courthouse. That's how identified these things are, okay? But what does that mean for this purpose? Well, first, I think actually the religious people are helping, believe it or not, marriage as an institution across large bodies. Now, often we'll think that religious people are, you know, these are not my terms, but many people in the United States think this, that, you know, they're very patriarchal or, you know, horrible or, you know, not kind to women or whatever, okay? Lots of things like that get heard in the ether, okay? When you drill down empirically, as I did for this chapter, you see that if you go to the next slide, that actually across large groups, people who are religiously married have less domestic violence, less divorce. They say they're happier. Now, maybe they're out of mind, I don't know, but they say they're happier. Who am I to decide? They're more collaborative, you know, they're more faithful and so forth. So there is a sense in which having religious people in this thing called marriage is actually norming, setting good norms inside of this thing, unless you want open marriages or something else. And maybe some people, you know, in a very pluralistic society is all good with that. I personally am not, and I think lots of people I know aren't, right? But in any event, you could decide that these things on this list are not good or good, depending on what you think. Now, what would you really be doing if you tried to get the government out of marriage? Go to the next slide. You'd be sort of taking these civil aspects and these religious aspects and divorcing them, like quite literally, divorcing. And I think that's a problem. Okay, now it's a problem whichever approach you take. And I think we have reasons to worry. So if you go on for a second to the next slide, if you just said you can have your religious marriage, no civil marriage comes into effect. This is the point I made to the senator. You will serve that population because there's a problem with matriculation. They may think that the religious marriage religiously marries them. We see polygamous couples today that still believe that in the West of the United States. And so if they never civilly marry, they may be under the illusion that they have the protection of law and they don't, okay? I also worry that, you know, the weaker party isn't going to be able to extract that civil remedy. Because I could just see some like, I don't know, dude say, no, we're not going to get this marriage, we don't need it. And a woman or anybody can be a vulnerable person, by the way. I want to be very clear about that. So the weaker earning party can be a man, but generally across large groups, it's a woman. And she doesn't have the power to force this outcome. When they both sprang into existence, there was no bargain that had to be made. And that's important. Now, I've also written in a different context about what happens in Sharia courts in Great Britain. And it was very analogous here. So I'm going to show you something with very cartoonish pictures. I don't want to offend anybody. I just picked people who looked like they were polygamous marriages or whatever. One of the things that I did in some work a number of years ago is just ask, okay, if you have a couple that's in Great Britain and they dissolve their marriage and they do it under sort of, you know, one of the 7 schools of Sharia law that can govern, that governs most predominantly in the West, what would happen upon the death of the husband? Okay, and in their system, you know, the parents are protected upon death, so the father would take like, you know, 50%. The mother of the deceased man would take like 25%. The lady would get like, the woman who's married would get like 25%. Now, I think we can be agnostic about this. I don't think we know if that's a better rule or a worse rule. I don't think we should be Western and necessarily impose these norms on people, okay? I think you can have a big pluralism in family law, but people have to understand, okay? If British law applied to this very same fact pattern, come forward for a second, the outcome for the woman would be 100% of all the money under British law. Now, whether you think that's a good outcome or a bad outcome, it's a different outcome. It's a wildly different outcome, and it flows out of the legal effects of marriage. And so if we allow people in the United States to just say, we're out of marriage, we'll break it up, here's this religious part. Whatever those religious norms are, may leave these women or whoever the vulnerable party is, you know, without far, far less than even the social safety net that comes out of this. So that's the only point I make on that. I keep going because I want to talk about Dobbs and then I end. Am I going too long? I'm not going to talk about time. Take a minute. Okay, so we can say this about religious marriage too. Anybody in a relationship here? Any kind of relationship, cohabiting, anything at all? Anybody have anybody? 2 of you, 3 of you have anybody? Can I take another poll? How many people have somebody? I have somebody. You have one? Okay. How many? I'm just gonna pick you. How many of you have bargained about the relationship and what you owe each other? Have you ever done this? But you don't have to take it every day. I mean, do you bargain? Does anybody bargain? I mean, we might bargain a little bit like, well, you know, I'll make dinner, maybe we can have sex, you know, something like that. But we're not bargaining about who owns the house, who owns the Ford F-150, you know, or whatever. Okay, we just don't do that. And the literature across large groups shows you that couples do not reduce their arrangements to writing or anything that anybody can see. Now, they could argue about it after the fact and say they did. And that's really not working out for the people in the palimony cohabitation cases in the United States. So that's problem number 1. Problem number 2, I think most of us don't know what to bargain about. So for example, is anybody here from the United States? How many people have any connection to the United States? Okay, I feel sorry for you, Jack, on this. Because I'm gonna ask you, there are 1,136 different benefits attached to a marriage in the United States in federal law alone. Can you name them all?
I know that there are burial rights in veterans cemeteries.
Yeah, there's social security inheritance. There's this and that. The veterans' rights are a very good example. Lots of the benefits attached to marriage in the United States cannot be bargained for because they are the third party, the world saying you will recognize it. You can't bargain yourself into that. And even between us, should I take the tax liability? Should you take the tax liability? No, we're not going to think about that. We might think, oh, I don't want to pay you alimony. I'm sorry, I really feel bad about it, but I don't. You know, or I don't want to share my property with you, even if you seem very nice. I don't. You know, we would think to talk about that, but there is so much more we would never even know to bargain around. So Jim Luke is saying that people should just, you know, we're so pissed off about marriage that we should just leave it to the side. It's going to hurt the very people that he is angry on behalf of. Okay, so going forward, I know you use the channeling function of marriage. A lot of people here probably wouldn't buy into that, so I skip it. Okay, so now here we are with Clarence Thomas and Dobbs. And you know, so everybody knows Dobbs at this point. It rolls that roll away. How's that? I'll cover Dobbs. You'll cover Dobbs. Okay, so we'll just push that off for half a minute. But we will now be in the United States, return to state houses to argue for access to abortion. Okay, I live in state houses. It feels like sometimes. Okay. And I think this is a very difficult moment because the kinds of things that we say in state houses are they're like a cup of water, right? That's the kind of argument you need to make. not outrage, not legal arguments, weirdly. I mean, we need a little bit of that. But the arguments are just going to be wildly different. One argument that I think we don't need to worry about, and I'm a Pollyanna, you can hear that, right? It's one of the reasons that I've been successful, weirdly, is because I convince people it can happen and then they try. But bracketing and recognizing that I'm a Pollyanna, I do not believe that we will revisit same-sex marriage. And the reason I don't think that, despite Clarence Thomas putting this in this concurrence, which I think, I just can't understand why he did this. Okay. Because it stirs the pot in ways that are just not cool. Okay. But the reason I believe that we will not roll back same-sex marriage is because when you look at how we as a people in the United States have looked at abortion since 1973, we have become more divided. We have been consistently divided. Even across large groups, we believe that abortion is a tragedy and that there are exceptions into which abortion should be placed and are made understandable. And here I'm just being descriptive of Gallup data, Pew data, okay? And that's been a thread through. If you go forward, what's happened with same-sex marriage is a dramatic increase of people who say, I don't understand how these two women are different than Jeff and Nausica, or how these two men are different than Jeff and Nausica. And Americans have been able to see the humanity in the need for people to have the protection of the law, because marriage does provide, for better or worse sometimes, a cocoon around these folks, and it provides rules to help them understand their relationship to each other. So Americans believe that. They don't have the same union head. They're not the same way, okay, on abortion, and never have that. And then you have actual people who have married like 1 million families. And to try to roll back their marriages is just as dopey and out of mind as getting the government out of marriage. Okay, now it may be that some parts of the United States, people are just so angry, okay, or so mean, or whatever is happening, that they're willing to do that. But I don't think so. I actually think that these families have dignity. I think people have recognized they have dignity. The law has instantiated the dignity of those relationships, and I think they will hold. And I think with dogs and everything that happened for Clarence Thomas to say otherwise was just so unnecessary. That's it. Thank you.
Thank you, Robin. This was fantastic. I'm gonna give the floor to Noy Naaman from the University of Toronto and SGD candidate, and Ayelet Leshem-Pigat, Dean and Professor of Law of the Academic College of Law and Science, for your chapter about abolishing legal marriage in Israel as a Thank you. Good afternoon, everyone. Congratulations, Jeff and Nausica, for this wonderful book. Thank you for the opportunity to be part of this project. We will try to present a more complicated version of the idea of abolishing legal marriage and suggest that it might be a solution, at least in Israel, for the continuous marriage problem in Israel, and a solution that might be of mutual interest of both queer activists and certain religious groups. Now we have 17 slides and I have one of you on time, so each time we'll try to see if we can work this out. Okay, so to the next slide, please. We divided this presentation in a manner that I got the easy, descriptive part. I'm only going to describe to you the marriage problem in Israel, the partial solutions adopted by the Israeli legal system,
and shortly explain what does abolishing legal marriage mean. And here Robin already started to describe, but I will elaborate a bit more. Then Noel will do the difficult part, which is the normative argument, and you have quite a bit of time with, answering Robin, and he will present why it can be considered a queer project and might also be an interest of religious groups, but not like the version that Robin presented. So first, a quick and very brief introduction to, we have to go too fast. Yeah. This third slide. Yes. Yes, exactly. Yes. Okay. So, under Israeli law, there is basically no civil marriage. In fact, there is no uniform territorial law that applies to either marriage or divorce. Instead, the personal law of the marital parties govern these matters. Jeff mentioned that a similar system exists in India, but in India, alongside the religious law, you do have civil law of marriage that applies to everyone. In Israel, it's only religious laws. And so that means that, and the personal law of Israeli citizens and residents is the religious law, but only if they belong to a recognized religious community. This means that if you're Jewish, you're married under halakha Jewish law. If you're Muslim, you're married under Sharia. There are 10 different Christian denominations that are recognized, and people that belong to these religions marry according to the relevant ecclesiastical law, and Druze. That's another group. If you don't belong to one of these groups, you don't have a personal law that applies. So as you can imagine, this religious monopoly over marriage and divorce in Israel, it infringes the right to marry, restricts the right to divorce, discriminates against women, and infringes upon freedom of conscience and religion. I will elaborate a little bit on next slide. The fourth one. Why infringement on the right to marry? So because no civil marriage exists and religious marriage exists only for recognized religious communities, so if you don't belong to a recognized religious community, you basically don't have any applicable law under which you can get married. In addition, many interfaith couples cannot marry in Israel because the recognized religions in Israel, most of them don't recognize interfaith marriages. The exception is Sharia, Muslim law, that recognizes marriage between Muslim men, only men, and Jewish or Christian women. But other than that, interfaith couples are unable to marry. Of course, same-sex couples cannot marry in Israel because none of the recognized religious communities in Israel, they recognize the relevant religious law, they don't recognize same-sex marriage, and there are those who do not want religious marriage. Okay, briefly, violation of freedom of religion and freedom of conscience. Again, if I don't want religious marriage, I cannot get married in Israel. And you should know that religious affiliation in Israel is irrespective of religious belief. I can declare I was born to a Jewish family. Okay? I can declare I'm atheist, I'm Christian, I'm whatever. If the rabbinical court says, well, you're Jewish, then I'm Jewish for purposes of marriage and divorce. And vice versa, people who are people from the former Soviet Union and from Ethiopia, they come to Israel, they feel Jewish, they practice Judaism, but if the relevant religious courts don't recognize them, then they don't belong to the religions that they feel they do. Okay, next we have, and I will not, there is also restrictions on the right to divorce. I will not elaborate on that. and the patriarchal character of religious laws and marriage and divorce in Israel. Okay, so these are the problems. But next, the Israeli legal systems over the years adopted several solutions to provide at least some remedy for these difficulties. For example, civil marriage conducted abroad. If I go outside of Israel and I get married in a civil ceremony, it is recognized. Okay? In Israel, sometimes partly, sometimes completely, it doesn't really matter for our purposes. Non-marital relationships, cohabitants, they have since the 50s, they have similar rights and obligations as married individuals in Israel. And there is also legislation, it's very tiny, it's just another solution that provide some solutions to those who don't belong to any religious community in Israel. But of course, these solutions are considered unsatisfactory. And this is why the debate in Israel continues. Okay? People say we need something different. Now, if you look at existing academic debate, public debate, in Israel, they focus on two options. One, okay, we will introduce civil marriage alongside the religious marriages we already have. Not to replace, but to add, like India. Okay. Another proposal is to replace everything, to have only civil marriage. We will not go into discussion of these options, but the idea is why we want only one single option, because choice is problematic in family law. And if I have the choice between civil marriage and religious marriage, and I supposedly chose religious marriage, then the incentive of the legal system to provide a remedy will be lower. But in this paper, we focus on another solution, which is abolishing legal marriage altogether. The last point for me will be to explain what do we mean by abolishing legal marriage. And I need to elaborate on that because of Robin's paper. So of course, no one says that ceremonies, civil ceremonies, religious ceremonies will be prohibited. You can have whatever ceremony you want. But these ceremonies as such will have no legal implications. Now, of course, the question is, okay, so what is the alternative? And the alternative vision that you can offer, they vary across the spectrum. On one hand, and Robbie mentioned it, I think this was the the Indiana option. The regulation of adult intimate relationship. The state removes itself not only from marriage, but from adult intimate relationship, only contract law, tort law, unjust enrichment, bargaining. Okay, this is one option. But this does not have to be the only option. You can have an alternative institution, an alternative civil institution, not marriage, because marriage will explain why marriage might be problematic. You can have a different institution, and this alternative institution doesn't even need to be based on romantic sexual bonds. It doesn't have to be limited to a couple. It might recognize platonic relationship, threesomes, polyamorous relationship. Okay? So it can be an alternative institution that can provide safety nets. It doesn't have to be based on bargain. It can provide safety nets, but through an alternative institution. Now, of course, whether we adopt the idea of abolishing legal marriage or not, it depends on the version of this argument that we adopt. Okay? So from here to you know.
Thank you, absolutely. So I'll take the second part of the presentation and
They are the same person.
Yes, we are the same person. I did the easy part.
I will talk about the potential queer religious coalition around the legal marriage in Israel. So abolishing legal marriage seems the interest of many queer people. And when we say queer, we don't mean only LGBT people, but anyone who resists sexual regimes of normalization. So queer scholarship and activism around the world and also in Israel offers three lines. Do you mean? Yes. One second. I'm only one.
Yes.
Oh, it's great.
Yes.
So queer scholarship offers three lines of criticism around marriage, all of which we argue applicable to the Israeli context as well. So the first line picks up on the earlier feminist critique that criticized.
No, before that.
Before that criticize that the first one, the feminist one that says that marriage is inherently oppressive and heteronormative institution. And this line of criticism is particularly relevant to the Israeli context, where the legal institution of marriage, as I explained, is largely shaped by religious perceptions of marriage, which reflects traditional gender roles, patriarchal norms. For example, the obligation of spousal support is still gender for a couple who are married in Israel. The second line of critique focused on the exclusionary nature of marriage. This is the exclusion of pattern of life that don't conform to marital models, and we speak about people who want to live alone, those who are in poly relationship, or even platonic friends that want to support each other financially and emotionally. Also, we think that this line of criticism is highly relevant to Israel because marriage, as I explained, is very exclusionary in Israel. Many different sex couples are also prevented from marrying in Israel. And also, if you think about unmarried different sex couples, which are known as recorded spouses, they are also subject to similar legal framework that mimic marriage and exclusionary nature. And this is the third kind of critique, which, and I think maybe it's responding to a role, which says that, which highlight the disciplinary function of legal marriage. And the concern is that the right to marry becomes unions, device to which intimate practice scrutinize eyes of the state. So of course, it's not critique that are unique to marriage, it's also critique that common around parenthood. And the concern is that something valuable, namely sexual freedom and diversity of intimate relationship, can be lost. And we should emphasize that it's not one. Despite this three-line of criticism, queer scholarship emphasizes that the objection to the institution of marriage should not undermine the struggle for full equality for queer people. Namely, extending the access to marriage and making everyone getting in is not the only means of achieving equality in this respect. Equality can also be achieved by keeping everyone out, namely abolishing the legal exclusion of marriage. So I will turn now to the other side of the potential coalition, which is the religious. So we identify a sort of religious support for abolishing the marriage. I thought it doesn't feel very obvious, especially in Israel, where religious law of marriage are endorsed by the state. However, abolishing legal marriage in Israel also might advance various interests in Israel. So as I explained, within Judaism, only the Orthodox ceremony is recognized for the purpose of marriage and divorce, which means that Reform and conservative Jewish ceremonies are not recognized, and even their interpretation of the Jewish marriage and divorce law. And against this backdrop, we recognize the growing practice of unofficial religious Jewish marriage, which takes place outside and against the Shift rabbinate authority of the Orthodox. In this practice occurs in a variety of Jewish circles, not only among who identify conservative or reform, but also within the Orthodox community. And we can think about various reasons why they chose this path, either because they enforce the ideology of the Orthodoxy probably, or because they share aspects of ideology which embrace a different vision of marriage than the Orthodox. But there is three. And I want to get to our point. Still, it's arguable whether unofficial religious wedding ceremony and queer critique of marriage had a similar vision for God's future. Some participating in private religious ceremonies strive to abolish the Orthodox monopoly. This ceremony do, however, wish to explore alternative to marriage, whether it's civil or religious. However, the common theme that emerges is the desire to care about the space that exists outside of and works against the revelation of marriage. And bearing in mind how this private practice undermines state authority over marriage, we could notice how these private religious ceremonies merge with queer critique of marriage that aims to disrupt the power balance embedded in this legal institution of marriage. And this community similarity paved the way to think about a new, yet plausible religious queer elements. So I just will finish with, even if this coalition can be formed around abolishing legal marriage, the question that remains is how it might look like. And there are two questions. The first one is whether the alternative should be based on general private law or a new legal institution has offer. And if a new legal institution is created, whether that institution should center on romantic-based relationship or endorse a variety of committed relationships. As we discussed in the chapter, and if you want to know the answer, you read our chapter. This question is very complicated from queer lens. However, we think that the ambiguity and the uncertainty around these questions could lie the foundation for further and more advanced debate around the role of marriage and whether we need marriage today in Israel.
Thank you so much. So just to give you a sense of how each of these chapters, fits into the schematic of the book, Robin's chapter was in a section that we configured it as religious queer perspectives, and Islands and Noise paper was in a section that we called queer religious perspectives, trying to suggest actually not. It's hard to have a sharp dividing line between queer religious perspectives. The next paper by Laura Kessler from the University of Utah is in the section that we configure as future trajectories. So I'm super eager to hear about this. And the name of the chapter is, the title of the chapter is Achieving Equality Without a Constitution. I think that'll be very important. Lessons from Israel for Queer Family Law. So Laura, thank you so much.
Can everyone hear me? Okay, excellent. Well, thank you so much. I am so happy to be here, really in person, which is a very big achievement for everyone. And congratulations to Jeff and Nausica for this really amazing book. I want to say this was, I think, a pandemic baby, maybe. It was produced under conditions of, stress and uncertainty. And I think this just makes it even more sweet that come to fruition. And it has so many really amazing contributors and such an important topic. And also in such interesting ways, right? I think that's what's so special about this collection, is there are so many different perspectives in this book. And I haven't read all of the chapters yet, but all that I have, including my own, obviously, is that it's really a diversity of opinion, and just like there's a conversation in this book, which can be a foundation, I think, for continuing this conversation. So really congratulations for this publication. Okay, so I'll begin like this. We have seen in the United States an unraveling of basic constitutional rights to privacy and perhaps soon to equality. 2.5 weeks ago, a majority of the Supreme Court held that the Constitution of the United States does not confer a right to abortion and overruled both Roe v. Wade and Planned Parenthood versus Casey. The decision, as Robin said, leaves the abortion rights or restrictions to be defined at the state level. The decision was described as a victory for the Christian right in American politics. Officials in the Catholic Church and the Southern Baptist Convention celebrated the decision. In Dobbs, 5 justices voted to overturn Roe: Samuel Alito, Amy Coney Barrett, Neil Gorsuch, Brett Kavanaugh, and Clarence Thomas. 6, the Chief Justice, John Roberts, balked at overturning Roe. He would have preferred to do a more incremental approach, but he did vote to uphold the Mississippi abortion law, which was the subject of the litigation that bans all elective abortions after 15 weeks. All 6 of the justices who voted to overturn Roe were raised Catholic. Justice Alito's majority opinion is based on an originalist, textualist approach to constitutional interpretation. He wrote, abortion couldn't be constitutionally protected until the latter part of the 20th century. Such right was entirely unknown in American law. This reasoning has led to speculation that's been commented and discussed here, that the court's conservative supermajority is just getting started, right? And is going to roll back other fundamental rights. Now, to be sure, Justice Alito's majority opinion takes pains to say that nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. One of the main distinguishing features is that he says, obviously, abortion is the only right that implicates another potential life, but the other rights in question, such as the right to sexual privacy in one's home or to marriage of same-sex couples, et cetera, doesn't have that kind of implication. So he's sort of trying to cabin it off as I don't know, one train only, one-off kind of a situation. But I think that many progressives feel that this statement rings false. The reasoning of the decision, right? The idea that if the words are not in the Constitution or the right did not exist when the Constitution was written, that the right should not exist today would cover a large number of rights that were not, the founders and the drafters of the Constitution had no conception of, even a basic right to equality, of gender equality, of sex equality. This was a concept that was read into the Constitution, into the meaning of the Equal Protection Clause in the 1970s, very late after the Constitution was written. Again, the right to sexual privacy is recent, the right to interracial marriage. There's so many rights, speaking of how, a large number of rights that are not in the text of the Constitution, were not on the radar of the founders, and not really what they were thinking about. And so basically, the fear is that, if it's into its logical conclusion, the court's reasoning, which refuses to recognize unenumerated rights, which are not explicitly set forth in the Constitution, that these other rights are in peril. I'm less optimistic than Robin that these other rights are on solid ground. I think we can come up with creative ways to distinguish this case. Constitutional law professors, their hands are sweating, they're like, what are we going to say in the fall when we get to teach con law to our students? How are we going to teach Dobbs at the end and tell them everything they just learned is bad law, or is it going to be teach it at the beginning and then spend the semester exploring? There's a real question. I think one of the main Kenji Yoshino had a piece in the New York Times, and I think it was very well written and thought out, that many of these decisions are also based on equal protection, not just privacy. And so I think the best legal argument would be that there's another leg to stand on. That leg, again, is maybe a little wobbly, the table is falling, but I think that we could say, for example, that Obergefell and the right to interracial marriage and some of these other rights are based on equality and privacy, and so maybe we can put them off in a corner and say they're safe for now, but I just don't know, okay? And that's just the latest development. And I spent a little longer than I wanted to on the Daubert opinion, so I won't go into all the other decisions of the Supreme Court that have been rolling back rights like to contraception under the Affordable Care Act, the right to adoption by same-sex couples. I mean, this is a major, all these developments. I guess it's basically what I want to say is that despite the increased acceptance of pluralistic family forms, and if you look at popular opinion, it's, the majority of the United States, even in mainstream religions, is out of step with this court's decision. That it just still feels like, it seems like the United States is suddenly awash in a kind of religiosity. And so it's with this quickly emerging reality and the rollback of constitutional rights, what my chapter tries to do is to think about Israel as a window into how we can, into this issue and what we may learn. Now, this is sort of a funny approach to things, I think. It's very unique to my personal experience, but I had a Fulbright in Israel a couple of years ago, and I still am spending years trying to figure out personal status law in Israel, which I'm still not there. I feel like I'm peeling an onion, and every time I think I understand personal status law in Israel, I realize I don't, and that I'm sitting on a panel with some of the top experts on personal status law in Israel. So I won't even pretend to have an expertise, a deep expertise. I have a superficial expertise, okay? But I think what I have gathered, and I think is accurate, is that Israel is a very interesting country because, as Ayala said, and Noy, Israel has no civil marriage, and formally in their legal system, the religious authorities control marriage and divorce and some other family law matters. And so if you just look at the formal law, you'd be like, oh, it's a fundamentalist, backward legal regime. But as anyone who does good comparative law knows, a comparativist, you have to look to the functional equivalence in two countries. You can't just look to the formal law, right? And what we see in Israel is that there's a number of solutions and compromises, perhaps because of the fact that Israel doesn't have a written constitution guaranteeing its citizens a basic right to equality. And I have to be careful there because I don't even know if I'm saying that right, but I think it's sort of basically right. That there's not a formal constitution the way the US has one. And so I think Israel's a generative case to study and examine the possibility of developing pluralistic legal responses to family regulation, particularly in context without robust universal constitutional protections for women and queer families. And the circumstance that today I would have never thought, right, is the US is sadly approaching, right? So now we need, instead of pretending we're the leaders in fundamental rights, to be looking to other countries that have been more creative than we have, I think, in addressing, figuring out how to create compromise, as well as to give rights and dignity to people without a hard, formal legal protections in a constitution. So I'm going to give you a couple of examples. Actually, Ayala and Noy covered some of these, and so I'm not going to go into a lot of detail, but basically, I'll just give you two, actually. So the first is in Israel, there's a very robust system of unmarried partnership rights. They're called reputed spouses. It's actually one of the most progressive nations in the world, in Western countries, with regard to legal rights and obligations to partners without formal marital ties. Reputed spouses are afforded a wide range of rights that are almost identical to the rights enjoyed by married couples, including third-party rights such as Social Security and disability, death benefits, much more robust than in the United States. The second is there are, I think, pockets. That's what I want to say because again, I think this wasn't well covered. But the second is something I'm finding with the more I dig into this is that there actually have been interesting, and I think there might be some disagreement about how progressive it is, but I do think that the Israel religious courts have developed some interesting, innovative interpretations of religious law to at least modestly even the playing field. Like, for example, in the area of divorce, where in Israel, the formal rule is you can't have a divorce without your husband's permission, which you can't have a divorce without your husband's permission. But recently, there's a case I read about where a rabbinical court found a textual basis in Jewish law to annul a marriage where a husband refused to grant a bill of divorce for an extended period. This was a woman named Zviya Gordetsky. Her husband, she was a domestic violence victim for almost 20 years. Her husband unfalteringly refused to grant her a divorce. And finally, in 2018, with the assistance of a women's rights organization, Susan Rice was a lawyer, and she basically, she composed an alternative court of rabbis who would be a little more progressive in their interpretation of religious doctrine. It's a rabbinical court because that's the only court that can annul a marriage, to end a marriage and is sorry, I should be careful here. A court actually has no jurisdiction to terminate a marriage, but to hear a claim of divorce. And so this rabbinical court basically applied a more progressive interpretation of Talmudic doctrine, which said you could used to be able to get an annulment for disgusting bodily. You could get an annulment if you couldn't basically have sex with your spouse because of bad halitosis or impotence or various bodily problems. But the modern interpretation was that the Talmud could be interpreted to annul this marriage based on refusal to give a divorce. Okay, the chief rabbinate of Israel, which oversees the rabbinical courts and Jewish personal status law, will not follow this more progressive interpretation. But the private rabbinical court convened at the urging of her lawyer and agreed to follow it. And this was enough for her, which is interesting. So in her community, according to her belief, she feels that she's divorced and she could move on with her life. Okay, so those are the examples I want to give. Oh boy, 1 minute. Okay, so oh boy, I want to know, what can we learn from these examples? Okay, so this is what my chapter is trying to do, is what can we learn? What can the US learn? Right? Because I think I've given up on trying to say what Israel should do, because I can't and never will be an expert on Israeli personal status law. I don't speak Hebrew, but what can we learn? So the first is that I do think that as a matter of framing, that I think that we can understand non-marital partnerships rights as not a threat to marriage, right? It can be understood as an alternative to marriage. And that, queer advocates and theorists oppose the heteronormative assimilationist pull of marriage. Religious traditionalists also want to preserve a heteronormative assimilationist approach, understanding of marriage. And promoting rights for non-married cohabitants may be something that, as other than marriage, might be something that's attractive to both progressives and religious conservatives alike. And I do think this is somewhat of a story of what happened in Israel, is that the non-marital partnerships in Israel actually preserve traditional marriage in a way. It's sort of like a pressure escape hatch. And so I wonder if we in the United States, as opposed to arguing that the alternative status is the same as marriage, we could think of it as alternatives. And I'll give you one recent example, was the Uniform Cohabitants of Economic Remedies Act, which is a new model law in the United States, gives unmarried cohabitants the same rights to contract as ordinary individuals in the United States. And I was part of the drafting of this. I actually wasn't part of the drafting, I was an observer. And part of the conversation, which I think made this draft and this proposal successful, was that the group eventually came to an agreement that what they were not doing was creating an alternative status, but what they were doing is creating a pluralistic alternative that would not really be marriage. And because people who are many unmarried cohabitants don't want to be married, but it would give them, help them better individually promote their vision of how they want their families to be recognized. Okay, I'm out of time and I had a couple other insights, but maybe I'll save them for the Q&A. Let me just, I'll just say it real quick and I won't give details. But I guess the second insight is that maybe we should stop looking to courts all the time for these remedies, and particularly in the US, as courts become more conservative. Maybe actually religious organizations and institutions can engage in internal self-reform, and some promising, progressive developments might come from inside religion. That's the second insight. And then the third is, I really think that it would be interesting and exciting to develop an informal private legal pluralism. The idea that maybe the solution isn't recognition by law, but it's the flourishing of informal solutions sort of like in between law and non-law. Like, it's always interesting to me that this panel in Israel is not a formally recognized legal rule, but it worked for the parties in it. And so I think it's exciting to think about creatively about pluralistic solutions that are not based in formal law, but that are centered in localities and communities where the parties and the people inside those locations and communities have the ability to normatively develop their own sort of legal vision and practices apart from the grip of the state. Thank you.
Okay, thank you so much, Laura, and all the authors. Now we're going to turn over the book or the discussion of the book to commentators, two different commentators. Our first is Professor Adrian Davis from Washington University in St. Louis. So Adrian is going to be joining us via Zoom, hopefully, if we can get the technology to work. But Professor Davis is the William M. Van Hook Professor of Law at Washington University in St. Louis, and is also a professor of organizational behavior and leadership. And she is also the founding director of the relatively new Center for the Study of Race, Ethnicity, and Equity. Davis is a feminist and critical race theorist who focuses on the law of daily life, or how law regulates and affects people's daily interactions, decisions, and identities. And I just wanted to say by personal anecdote, Adrian is also one of the ways that I got into this project 10 years ago when she invited me to participate in a special volume of the journal at Washington University. And I, through the opportunity, began to think about queer religious alliances in family law politics in the US at that time. So it's really quite an honor for me for all of us to hear from her for 10 minutes, and then we'll turn it over to our next commentator and then open it up to the audience. So Adrian, are you there?
Can you write it in chat? So if you can hear us, our idea is to perhaps Ruth, if you also agree, keep it up.
No, we can't hear you.
Okay.
So we have a.
Is there a volume?
Yes, some.
Okay. Yeah.
Yeah, these people are on.
Yeah. Maybe do we want to speak for?
Okay, can you hear me now?
Oh, yes.
Okay, so I apologize that they're moving my office this week, so they gave me a different office, and I've been following all of you, but I guess I didn't realize that my camera wasn't working until I just went to try to see. You all couldn't see or hear me. So anyway, I'm on my phone now. Hopefully you can see and hear me. Thumbs up.
Yes.
Yeah.
See and hear me. Okay. All right. So I apologize that I'm on my phone. But I just think it's so classic that I've been on sabbatical for like 18 months and this is the day they decided to move my office. But anyway, okay. So do I have like 12 minutes, Jeff? Or,
Yes.
Okay. So I want to thank Jeff. And do you pronounce your name? Is it Nausica?
Nausica.
Nausica. I want to thank Jeff. I want to thank Jeff and Nausica for queer and religious alliances in family law politics and beyond. This book is important and compelling, and to me personally, it was provocative in the best and most generative ways. And so I'd like to outline some of the claims and insights that I found most thought-provoking, focusing maybe on some of the chapters that we didn't discuss today, and then also suggest some ways that's been the book has been very generative for my own work, and that I anticipate will be generative for other people working in the fields, and then conclude with a set of questions. And there's like one thing in particular that I'll sort of just use as an example of something that I desperately want to know more about. So there was just an incredibly thick and diverse set of insights and claims that I took from the book. And, first was the potential to really mainstream legal pluralism into family law and into the regulation of intimacy. Even as we need pluralism desperately in family law, marriage equality already had reinforced, and post-Dobbs, I think we all anticipate, will reinforce even more what Mario Cronche characterized as, as legal monism. This pluralism has the capacity to depart from liberalism as the ideal state of being, revealing received truths as historically contingent, and launching a debate into whether monism or decentralization and pluralism better fosters our goals of civil society. These and other insights the book offers about the state, I anticipate really can and should travel well beyond family law, and they have incredibly rich explanatory and predictive value of the political moment that we're in right now. Obviously, even though you all clearly wrote the pieces well in advance, I'm sure as you reread them and read each other's, you saw how they are just incredibly devastating descriptions of our moment right now. And I think especially tackling the state in these fragile times, the volume to me gave a deeply empathetic, and I'm still thinking through how persuasive it is for me, but a deeply empathetic recounting of religion, and including the religious right as a desire for collectives and community and solidarity that was sort of taken hostage by the rise of the state under modernity. So I really want to thank you all for that. So individually and taken together, I think the essays successfully undermine the longstanding view summarized by Mario that supposes a forever enmity between queer and religious groups, and that reproduces assumptions that queerness is always secular and that religion is necessarily heteronormative. Given the hysteria in our current cultural discourse, this book is an important reminder again of historical contingencies and political narratives of which we should be skeptical. And I recall on occasion, I've taught at the University of Alabama on occasion, and I teach stuff related to sexuality, especially in estate planning, and a lot of the students there, want to bring religious claims into the classroom. And I struggled with how to do that, but I tried to accommodate it. And so many of my colleagues said, that's unacceptable. There is no room for religion in the law classroom, right? Except as an object of discussion, but never as a set of subjectivities. And so this volume collectively, I think, gives me the vocabulary to explain how we can effectively empower claims about religion or religious frameworks and lenses in legal pedagogy. I appreciated very much what Cronche calls the post-secular moment as clearing a way for legal pluralism, which sets up a profound theme that threads the entire volume. And that is the potential for more of what I and others like Brenda Kosman and others call sexual democracy, here defined as a broad-ranging participation in crafting the laws that will govern all of us. And this was, I think, most profoundly made in Valenzi's beautiful recounting of her Waldensians and her call for explicit self-authorship. And I especially appreciated her harnessing of Jacques Martin's notion of sexual minorities as potential prophetic shock minorities who are crucial to animating democracy. That really resonated with me. Elaborating on that point about Valenzi and sexual minorities as shock jocks, these calls for self-authorship resonated deeply for me as a longstanding Black feminist, and the Black feminist project of centering what is currently on the margins. And that's not only legal norms, but also what so many of the projects did ethnographically and qualitatively, which is differing visions of the good life, and especially the good life under precarity and increasing precarity. As someone very much interested in the tension between formalities on the one hand and pragmatism and autonomy on the other, I loved the pairing of Fretwell Wilson and Valdeck with Valenzi's Waldensians, with the former fighting valiantly to keep the formalities of marriage, and the latter suggesting that they can be cast off in favor of other harbors. Finally, I offer, I just want to discuss one of the chapters at a micro level that I was really taken with, which is Gassmano's chapter on, I'm not sure, how do you pronounce this, Ohana?
Yeah.
Ohana.
Ohana. So her fight for the recognition of friendship was really just one of the most compelling I've seen. And I especially appreciated how she introduced into the volume precarity and care as key concepts and goals, and really grounding her chapter in distributive justice and resource allocation, making explicit and amplifying what I thought might have remained a little bit implicit in Fredson, Wilson, and Valdeck. And her takeaway, I thought, was such a smart leveraging of ethnographic and theoretical insights into a profound policy claim, which is that regulatory regimes, when properly and empathetically erected, can confer high cultural and relational capital on those with low economic capital. And I just thought that was so smart. And it's a great, I think the vocabulary that you used there was just incredibly smart. And I can see that again traveling to other work, even beyond family law. So just briefly, some of the things that really helped me, I worked on people who you might think of as intimacy minorities, and this volume helped me clarify some of my own work about them. Some of the sexual minorities I am looking at want more involvement with the state and more authorship. That is, they want to become strong sexual citizens. Others, though, very much want to be left alone and don't want recognition at all. And I did wonder, if the volume had space for people like that who just really want to be left alone. And I think here of some of the fundamentalist Mormon communities who really want to be left alone so that the leaders can continue their despotic tyranny. And I contrast that with other polygamists who I think very much want to seek state recognition. I've written about the split within the sex work community. And as I continue that work on sex workers, your book gives me a better, more finely tuned vocabulary to explain the split between sex workers who want self-authorship and who want to participate in the crafting of the regimes that will govern them. And again, those that just want to be left alone. I'll skip that next point. Finally, the book gave me a really helpful vocabulary for a project I'm finishing now on how mainstream sexual assault law can learn from the BDSM community. So the logical extension of self-authorship is the competition among regimes that several of the authors, especially Conche and Redding, on personal law and the chapters on Israel, I think especially those, really struck me. And I very much see, BDSM, members of the BDSM community as these prophetic shock minorities. And to me, it's really intriguing then, this project that I'm doing on how we can not only, they've already done self-authorship and have successfully introduced that into mainstream law, but I'm taking it to the next step and also want to make a set of claims about how mainstream law could learn from the sexual minorities, from the prophetic shock jocks, as it were, and could improve itself. And this, I think, again, would be the logical conclusion of some of that, logical extension of some of that competition that the personal law advocates encourage could happen within, within a more pluralistic society. So let me conclude then with a set of questions. So one thing that, as I said, I was very taken with Gusmano's chapter, and especially this sort of troika of heteronormativity, mononormativity, and mono-maternalism within these hierarchies, these regulated hierarchies of care. And this idea of mono-maternalism, I think, is so rich and fruitful. And I absolutely saw the ways that you were using it, I think, incredibly effectively. And yet I also wanted more. And so I found myself thinking about mono-maternalism, not only as sort of the descriptive claim that a child could only have one mother, which, obviously disadvantages many LGBTQ communities, but I also saw mono-maternalism as erecting the mother as the hierarchy in many families. And I think this is true in many ethnic communities. My understanding is it's very true within Italian Catholic communities. It can be very true within Jewish communities. It is certainly true within African-American communities. And so I wanted more about the mono-maternalism, not only in that it excludes multiple or pluralistic mothers, but also that it erects a hierarchy of a care provider, a mother who cares, but who through that care can inflict a lot of injury and also through the mono-maternalism later imposes and demands care based on it as well that can interrupt and disrupt efforts to craft the other kinds of families and friendships and regimes that Gusmano was calling for. Another question I had is really, I think that the book does such a wonderful job of clarifying what friendship means. And I won't read it because I was running out of time, so I won't read it. But I loved on page 90, I'm sorry, not page 90, but I loved some of the descriptions of friendship that we get from Gusmano in particular, and how friendship is distinct and different from family, but can itself evolve into a kind of family, but in a very, very differential way that rests on a distinct set of norms. I also got a very, wonderful, thick, understanding of what secularization is from Conche. And what I wanted was something deep and thick about the queer. I wasn't, in some instances, I felt that the queer was, let me just go down real here to, find it. Oh yeah. So at in the introduction, Nausica and Jeff tell us queer families embody queer resistance to normalization and family life as they challenge sexual regimes of normalization. And I wasn't sure then if so that to me was kind of a familiar definition of queer, in that it's people who are anti-normative, or not just non-normative, but who are anti-normative. And other parts of the book, I felt that it was more people who were non-normative, but not necessarily anti-normative. And then other parts, I felt that it was synonymous with sort of LGBTQ plus populations. And so it was hard for me to imagine exactly what some of the friendships and alliances would be, because I just wasn't entirely clear what this domain of queer was, the anti-normative, the non-normative, and the more, sort of the way people use queer today. The newer generations use it as synonymous with LGBTQ plus, which is, not the way that I've used it historically. So anyway, that's sort of just, one question. And then I'll end with two thoughts that are provoked by, James Baldwin and Derek Bell. And, Baldwin says, sure, we can be friends unless you're, we can disagree unless the disagreement is grounded in your belief, in your belief that I'm not fully human. And then Derek Bell, has his wonderful insight about how frequently minorities get things when the interests converge with the strategic interests of dominant groups. And so just to kind of wrap up, in the beginning, the book tells us it wants to move beyond armistice to actual alliances and coalitions and potentially friendships. So I completely agree with moving beyond armistice to actual coalitions. But I still found myself, back with that old Will Kimlicka question about the paradoxes of illiberalism, or of liberalism's tolerance of illiberalism, which is, you tolerate yourself into non-existence. And, in this moment, in time when, at least in the US universities, there's probably 70% of them that would, not want me to have a job because I'm a critical race theorist. And so it just prompts me to think really hard about people with whom I'm in strategic alliance. I believe in strategic alliances deeply. I believe in opportunistic and instrumental alliances, but I wonder about the possibility of true friendships for people who would, given their druthers, not have me speak, etc. And I do think that the book does a wonderful job of teasing out religious minorities, including religious conservative minorities, who don't necessarily have that streak of illiberalism. But I do think it is, it's an important thing to recognize in this specific moment, which I wouldn't necessarily have felt this way, say, 5 years ago. That also comes up just, to finish off, Valenzi gives us the cautionary tale also about not romanticizing minorities of any sort. I won't repeat it because I think she does such a wonderful job with it. And then the last thing I'll just sort of question, it's not a big question, is you know, the book uses so many wonderful terms. You know, there's friendship, bonds, affect, care. And I wondered, you know, where intimacy was in all of this as well. So I'll stop talking, but thank you all so much for the volume. Thank you for including me, and I'll look forward to the question and answer.
Adrian, fantastic. We could hear every word. Thank you so much for joining us from St. Louis. And yeah, stay online if you can.
And the invitation to Lisbon still stands. Thank you so much. So now I'll introduce our last discussant, Alfred Kedari. Ruth is an Israeli legal scholar and a women's rights advocate who's been working with the United Nations Committee on the Elimination of Discrimination Against Women. She's a professor at Maryland University and director of the Ruth and Emmanuel Rackett Center for the Advancement of Sex Women. Thank you so much for being with us.
Thank you so much for inviting me. It's a real pleasure, and it's an honor to have a chance to relate to this really wonderful project. And I will want to make 3 points. First, to applaud your project. Second, to express some apprehension about its underlying message, or at least what I take as its underlying message. And third, I'll try to say something in general about what I see as some common thread of the 3 presentations that we heard today. So the applaud, I think actually much has already been said. It's a real radical project. It's thought-provoking and even a provocative scholarship, and it draws us to unconventional directions in thinking, counterintuitive to what many of us are used to. So it's, and you said also it's very courageous. So I really applaud all this. But then I have some reservations and apprehensions. And what I think is that while it's really very tempting, but I cannot help but express grave doubts, sorry, about the possible political outcome of such a project of building alliances between queer and religious interest groups and communities. And we all know that politics, as the saying goes, it makes for strange bedfellows, but one should still be very careful whom she goes to bed with. And I think this ties up with what we just heard from Professor Davis. And as put very convincingly by Robin in her chapter here and in previous writings, divorcing the state from the institution of marriage will put many women in great risk of losing rights, of not being able to protect their rights, and in general, it will be women who will be harmed by this move. And while I wholeheartedly support LGBTQI+ struggle to gain equal protection and equal access to all rights and privileges and benefits, I'm not willing to sacrifice hard-fought and hardly earned rights, which are in fact being jeopardized as we speak, rights of half of the world. And if, as it seems to me, by broadening the recognition of unconventional structures of close relationships as families, and this is what I see as the underlying tone of the book, broadening the recognition of unconventional structures of close relationships, and I'm purposefully not saying intimate relationships, because again, this goes to the last question of what we heard just now, because you do suggest at some points to take intimacy out of this definition. So if we broaden this recognition to include also polyamorous relations, which will inevitably be more polygamous relations, we will in fact legitimize polygamy, then I'm not on board of this project. I would be willing to consider supporting the move if I were given a convincing distinction between the various non-dyadic structures, but I cannot think of one. Now, it's not that I cannot think of one. I could make distinctions, but I cannot count on them being accepted by policymakers or by the public at large, not at this time and age. Constructing a distinction based on feminist arguments will not fly in this day and age. Explaining that polygamy has long roots in oppressing women, that it was and still is in many parts of the world the optimal cultural and often state-sanctioned method to control women, including women's sexuality and women's reproduction, this will not be accepted as a valid argument. Again, not at this time and age. It's just like the failure to argue against the erasure by the LGBTQI advocates of the word woman or women from the abortion and reproductive rights debate. Raising feminist arguments to explain the historical, political, and sociological context of a complete ban on abortion simply doesn't receive audience. So this is where my caution comes from. Now to the common thread in the three presentations. I think that we can say that they all describe different aspects of the proposal to, broadly speaking, abolish marriage, or put even more broadly, to divorce the state from the regulation of all people's intimate relations, whether it is in the entry point of marriage, as we heard from Adrian Davis and from Robin, or at the end point of divorce, as we heard from Laura. So that it will not be the state's formal mechanisms who are to be the arbiters of people's relations, but these people's relations, they will be left for the people themselves to regulate, to self-regulate, to structure, and if there is need to resolve conflicts or disputes, they will be resolved by principles and rules drawn from general areas of law, including contracts, trusts, torts law, unjust enrichment, etc., etc. Moreover, there is the potential, as described in Ayelet and Noy's article, although it is not clear to me whether they themselves advocate for that direction, for going further than that and demoting those relationships that are traditionally safeguarded by the institution of marriage, namely sexual dyadic relations, and broadening the class of relations that merit some degree of protection and respect to include any structure of long-term commitment between adults for mutual care and support. And this actually brings me back to my previous comment, to the caveat, to where I'm very hesitant, pointing to the risk that I see in this move in losing protections mainly for women. Moreover, I do not think that this can be presented as a joint project for queer and religiously motivated groups. And here I talk specifically about Ayelet and Noy research relating to the Israeli context. I don't share Ayelet and Noy's understanding of the motivations held by those couples who conduct private marriages outside the scope of the rabbinate, or by the movement, whatever movement they represent, if they can be seen as representing any such movement. In fact, I'm actually conducting currently still ongoing study of this very phenomena of couples who marry outside the state rabbinate, couples who choose to marry, who have the choice of marrying within the formally recognized state-sanctioned marriages, religious marriages in Israel, and choose to marry outside the rabbinate. And my research shows that they are actually seeking the very traditional structure of dyadic relations. What they challenge is the state's regulation of the way to marry and the content of the institution of marriage, but not the actual institution of marriage and not the traditional way of seeing the marriage as regulating relations or as relating to relations between two people and not more than two people. Whether it is opposite-sex people or same-sex people, that's a very pluralistic understanding of most of these couples, but not beyond that. So the image of the conventional marital tie is still very much there, and many of them actually seek the religious marriage and even the Orthodox way of marrying, according to their understanding, challenging the understanding of the former rabbinate courts and the former rabbinate in Israel. Now, the bottom line, going back to what ties all three presentations together, and where my, again, my resistance, my hesitation draws on, is what I see as the critical importance of registration to safeguard rights and provide protection. And this is actually most apparent, Robin talked in length about that, but it's also very apparent in Laura's praise for the private Israeli rabbinical court's decision to free a woman whose husband refused to grant her the religious divorce, which is the only recognized divorce for Jews in Israel. And I agree, this was a very courageous and innovative step of all the parties involved, but it has no standing whatsoever for purposes of formally engaging with either the state's authorities or any other third parties in Israel and outside of Israel. So she may very well feel herself as being free, and I know that because she was also represented by the center that I'm directing at Bar-Ilan University, but it has absolutely no formal, legal, or practical ramifications in her everyday doing. Likewise, while the resort to counting on de facto relations, that's the reputed, the mechanism of reputed spouses or partners in Israel, I call them de facto relations, it's very tempting. And the Israeli case, as you all said, in fact shows that this is what drives those who seek social legitimation to their private weddings. We cannot ignore all the pitfalls of this venue. And it is not for nothing that one of the very first international conventions relating to marriage in 1954, I think, was the Convention on Registration of Marriage and Divorce. And the fact that the CEDAW committee on which I serve also constantly in its concluding observations warns states that do not uphold and do not manage the registration of marriages and divorces, warns them to do that, because this is being seen as the ultimate safeguard for vulnerable parties who are mostly still women in all parts of the so I think that overall, while, as I said, it's an extremely innovative and provocative work, the book in general, if we want to translate it to pragmatic, practical outcomes, I think I'm on the side of putting a red flag.
Thank you.
Thank you.
We can open the Q&A with him, Andres.
Hello, I'm Lars, and I will not sign the Q&A of our event, but before that, I would just like to pose a question. Is having a common oppressor sufficient ground to create an alliance between religious groups and peer groups? Is there a need for a common goal or value beyond the common harm in order to ensure genuine cooperation? And which value or goal could it be?
No, speak louder.
Should I repeat?
The microphone is on.
Is having a common oppressor sufficient ground to create an alliance between religious groups and peer groups? Or is there a need for a common goal or value beyond common harm in order to ensure genuine cooperation? Which value or goal could it be?
Okay,
So, and before discussing this and discussing these questions, we could also gather some questions from the audience and everyone that's on Zoom. Anybody have a question?
or comment?
Start answering, because it's a great question.
I'm going to start this one.
Yes, I think it's a great question that you posed. And I think that's the theme of the book. The answer depends on whether we are idealistic or pragmatic. Of course, we would like to say that we need something beyond, that having a common oppressor is not enough. But I think this book is about the compromises that we make and not the idea. So for specific purposes, I think it is enough.
If I can pick up very quick on this point, because it was a criticism that actually a chapter within the book raised by Christian Pless. He was very concerned that we might need dynamics of coalition, because otherwise we would just get together groups that have, especially from the religious side, the bad motives for getting together, such as preserving traditional marriage and the cost of forming LGBT couples, such as thinking about multi-party marriage. So that's, I think, a great point, and this chapter really pushed us forward in this attempt to understand if there's a quid plus that we need, and I think we do need. I think he's right. It's a hard question in the sense that it narrows the opportunity for coalition significantly. So I strove to think about how they could generally promote that family pluralism, and I came up with some examples such as extended families. I think that the Christian denomination might well have an interest in promoting the recognition of extended families, and it would also resonate with this sort of interest in recognizing relationships of care. And I understand Ruth's concern. I don't want to take much time, but I do understand Ruth's concern has been made over and over this objection when they were trying to pass these laws to recognize family relatives, and they were really trying to do so to our gay couple. That was the aim. It's pretty clear. We recognize family relatives because we want to make invisible the intimacy of gay couples, and this is not acceptable. I think you're right. It narrows the gamut of opportunities. So I think you're right, and this is an excellent question as well.
I just want to jump in and say that there's I don't know if tension is the right word, but there's a difference between the authors and the acronyms used across the different chapters. And this came up in the editing process where, your editors were trying to systematize the use of LGBTQ across the different chapters. And we had to kind of step in and say, no, this author is saying LGBT, this author is saying LGBTQ, this other author is saying LGBTQIA, and we're going to keep each author's voice or particular use of acronym as they wrote it originally, because there's a contested politics around this collective, and in some sense, this collective is a coalition of people and sexualities with different and contrasting interests and desires and intense disagreements. That is a coalition of convenience against the religious. I see one side of this question is already being formed by these pragmatist politics.
So, thank you very much for this very interesting religious group. My colleague and also my office mate, Nausica, for moving out these events. And so I am a family law scholar. I am among the contract scholars, and one thing that I did was spending some time in Tel Aviv University working with Dagan at the time where it was all about contracts, and so we were making fun. Everybody said we did not tell you what, but we're making fun of the very catchy title of this book, right? The choice theory of salad, the choice theory of beverage. That was good. So I was just curious to what extent, a narrative based on the liberal egalitarian, late Gaussian approach to human relationships that Dagan and Eller defend in that book, where there is a fixed obligation of the state not to stop at the majoritarian form of human of organization of human interactions, would actually create, as being considered. I did not have the opportunity to read the book yet because it was delivered yesterday afternoon. So yeah, so to what extent that fit normative commitment to liberal egalitarian understanding of autonomy has been considered or could possibly contribute or might actually become counterproductive for this kind of project that you are investigating. Thank you.
I had a question as opposed to a comment.
Yeah, go for it.
Well, so my question was the burden case. I don't know how many people know this in Great Britain, but I had the opportunity to talk to Ruth Beach, who's in the House of Lords recently, and there was a clash between her and another woman in the House of Lords about whether two women who had lived together forever should have the same step up in basis for the property at death. Okay, so the taxes, if they had been married, they would have not this tax. And but because they lived together outside of marriage, even though family, they were not given the same tax preference at death. And so the real question becomes how cruel that is, right? Why is it that the state, will recognize some relationships, but not others, when they're mutually dependent, and I think in many ways indistinguishable from marital rights? I think the Burden sisters provide the hard case for plurals. I think they really challenge the state to provide some remedy. With that said, I think it's a very difficult problem, like this idea of friends, okay? And I don't want to minimize this, but how many of us have fired a friend? Have you fired your friend? Ever had a friend that you fired? You just left, they're not your friend. We do this all the time, right? I mean, you have a deeper relationship with some people, and then over time it breaks. It's a very difficult, fluid thing. When we have family, like the Burden sisters, and they live together and it's otherwise indistinguishable, except they're not having sex, I think we can sort of come out of the marriage box or whatever, the even cohabitant box, step over one step and say we can recognize it because the state can understand the solidity of this relationship and be sure that they don't provide remedies where the relationship did not warrant it. But when you get to friends, it's a very difficult matter. I think we've limited these things to conjugal relationships because we think that people make different investments when they're having sex with people. Think about all the concessions you make to your sexual partner. Oh my God, right? You make investments in them in the ways that you simply don't make in your friends. Jeff is my friend. I haven't seen him in 8 years, whatever. It's okay. But a sexual partner that you haven't seen in 8 years, it's never going to go. So I think there's a real tension here about trying to move outside of sexuality. In insurance terms, the sexual relationship actually polices moral hazard. It keeps us from recognizing and investing in relationships that did not have the solidity of the cohabiting or the marital relationship. So, I understand the idea of caretaking. The Burden sisters seem like married people, just like, just as the challenge, just as profound as the challenge made by LGBT couples for why they were being left outside of marriage when people had identical relationships within. Burden looks like that to me. Friends, not so much.
Can I respond? I
Yeah.
think I will answer, not answer, but I will respond to your question as well. I think the distinction is not friends, sister, and this is my own personal view. I don't know, if not, we wrote this chapter together and maybe shares this specific answer. There is a difference between relationships that involve only adults, friends, sisters, siblings, sexual partners, and relationships that involve children. And this is the big distinction for me. If we're talking about family law, and Hanoch's ideal about, because he emphasizes autonomy too much when children are involved. And I think, Ruth, this is also a response to you, because the vulnerability of women is not because they are women, it's because they are mothers. So once children are, so this is the big difference, again, to me. And this is where I diverge from Hanoch, because when children are involved, with all respect to autonomy and freedom, and I mean born children, I'm not talking about children who are, once a child is born, it makes a difference. And the parents, if there are if there is more than one people, a parent, then they are connected for life. Why? Because they are parents together. And people need to understand that. I can divorce my friend, I can divorce my partner, I can even divorce my sister. I'm recording. No, I don't want to divorce you. Just send me a picture of her with my daughter. But I can never really divorce someone I parent a child with. But this is beyond this book, so.
Can I get in on this? Well, you go first.
I just want to respond to some of the the terms or the assumptions of the conversation. I feel like, Robin, sometimes what you're saying is you're making a lot of statements, like descriptive statements about behaviors in intimate and friend relationships, but it's already colonized by a heteronormative conception. So, for example, friendships in, let's say, more queer or gay or other communities, even like in minority communities that live in more communal type cultures, are actually lasting, and they are characterized by care and continuity. And so what you're describing is a heterosexual understanding of the distinction between a sexual relationship and a friendship. And so by definition, you've already baked in this distinction, which then you're using to justify to continuing the distinction. But the distinction itself is a heteronormative product of a heteronormative structure. So that's the first thing. The second thing is divorce is so common now. I don't actually agree. I'm not sure we can debate some social science stats, but I actually think some friendships in certain communities are more everlasting, more permanent, and have different normative meaning than marriage, which these days, you can be married for 10 minutes and get divorced by mail in the United States. So you're making a lot of empirical assertions that I just actually don't think are borne out in social science. So I think what we really need to do is go deeper to think about the categories themselves and how they came to be. The other thing I want to mention is my concern with this idea, this black and white idea that we have marriage and non-marriage. And I think that to some extent, Ruth misunderstood my point, which is that my vision of pluralism is not erasing marriage. And I don't think it's possible to get the state out of intimate relationships because it's just going to migrate into private law. And then, as I tell my students, marriage is con law, tort law, that's what family law is. It's a set of default rules for intimate relationships. And if we get rid of formal marriage, we'll just migrate these default rules into some other place. So I don't think much will be achieved, actually. And I don't think politically or realistically we ever are going to get rid, at least in the United States, eliminate marriage. So to me, this seems like a straw man and not a productive conversation. So for me, the question is, what if we have marriage, which we will, I think, for the foreseeable future, what alternative forms and pluralistic forms of middle ground, I guess is what I'm thinking, could be added, right? Not a substitute that would create more fluidity and ability to have more choices and perhaps have less of a normative pull about the right way to be. So, my lessons from Israel are not that we should eliminate marriage, but I do like the idea of more pluralistic approaches that would give more options to people.
Can I weigh in also on this real quick? Is that
Yeah.
okay? Yeah, I was having a similar, I think, reaction. And who was just speaking? I can't.
That's Laura Kessler.
Laura, okay. So, Laura, I was having a similar reaction, I think, to yours when Robin was talking, because the description of marriage is one, certainly it's characteristic of many people, but I'm not sure how normative it is, and I even resist it being heteronormative, because I think increasingly what COVID revealed is that there are so many people, identify as straight and as single by choice. And, friendships are, the deep sustainer of my life. And as Laura just pointed out, the friendships that I carefully cultivate, and there's all this, wonderful research going on now about friendships and the bonds, and even the sort of the scientific studies about different kinds of friendships and ways people sustain friendships. But I think we saw that during COVID, almost a return in some ways to almost kind of the AIDS moment, right? Except that this was much broader than beyond the gay community, in which it was friendships that really sustained people through this time. And at the same time, we saw many married people get divorced, right? Because they said COVID has shown us that we really, don't really, there was, that we really don't want to do it this way. And that just goes back to part of the question I had about how you all were defining queer, whether it was capacious enough to include sexual minorities like myself who are straight, but who are sort of resistant to mononormativity or monogamy. But I just wanted to kind of reaffirm what Laura was saying about confusing maybe descriptions about marriage with the normativity of marriage.
I respond.
Yes, and then I want to jump in as well and talk about COVID for a minute too, because my chapter is a bit about the synergies between religious and queer politics and different pandemics, the HIV pandemic and the COVID pandemic.
Yeah, I mean, look, I don't want to be dismissive. I'm not trying to suggest that people should be in a box. I started with the burden system sisters for a reason. I think it is a hard case for the government to explain why it does not support these women. I do think, though, there are indicia of a relationship that the state, when it decides to regulate families, can see. And friendships are sustaining. It's exactly right. But I could not, Adrian, neither could I, Laura, go figure out who are those 10 people in your life right now. And this brings us back to the point that Ruth made about registration. Marriage actually serves an important sorting function in society because people assume the mantle and they agree with each other that this is going to be a set of duties that they assume. The 10-minute marriage, yes, that you can quickly divorce, there isn't going to be many reverberations across that marriage because it's too short for the background set of rules to actually recognize anything in. But the function of the marriage is, had it endured, that over time, people have more self-investments in each other. And the point that I wanted to make to Ayelet is it is not just mothers and it is not just parents. I actually think it's very gendered in the way that investments are made across heterosexual couples, but even in same-sex couples, that there's one person who invests disproportionately and who is more harmed by the relationship than others. And that is what I'm talking about. Now, you can be harmed by your friend. Let's say, for example, I moved a very big boat to a whole different marina, which cost a lot of money. So that it would be next to my girlfriend's boat, okay? Not my sexual girlfriend's boat, but just a very good friend who promptly decided to leave again. Okay, I can be harmed by following my friends around. All of us can. But we can't be sure. The state can't. When it tries to remedy and smooth over those things, it's very difficult for the state to know. And I think that's the reason conjugality has been so sort of grabbed upon. And I agree with you, Adrian, entirely. That is too narrow. But I'm afraid that we don't have a very good metric for policing fraudulent claims from non-fraudulent claims, and frankly, buffering people from the state. Because when Sandy moved her boat, that's on me. But for me to actually sue Sandy for moving that boat and I followed her, I don't know. I think we stay out of court on that.
Yeah, I just want to jump in and say that I think that the pandemic situation, has revealed a lot of tensions and perhaps a non-sustainability of ways that we talk about certain things. There's also kind of revived the importance of appreciating vulnerability across all sorts of communities, whether they be queer or religious communities. And one of the things that I focus on in my chapter is trying to read the litigation around the right to engage in religious practice communally in the United States in a sympathetic way, which sees parallels between arguments that are also made within queer communities and continue to be made in queer communities about access to sexual establishments, not seeing them as just the opportunity to engage in narcissistic self-serving behavior, but as an opportunity to meet friends. And I think that both moments reveal really intense vulnerabilities that a wide variety of people can understand and appreciate. And I'd be curious to know, globally, whether any of these efforts to allow, the friend exception to visit, during COVID, whether there was any sort of religious opposition to that, or queer opposition for that matter, right? What did COVID allow people to understand that, pre-COVID, people were too entrenched to allow another person or another community. So I'll end there, but I'm curious to hear more from the audience, whether online or in person.
Question there, please.
So our question is to Professor Nausica, and you said right to the beginning that revealed that the book does not address all the questions related to the traversible problem related to the law of queer and religious problems. So we want to know what would be the next questions to address in a possible future book, or if there was something that you left apart from this book that you really wanted to address?
A lot is left out. A lot. I think we don't have solutions. We just had this intuition that there might be something out there that we were not analyzing under sort of a coherent framework. So we were trying to make sense of why in Alberta conservatives were recognizing friends. Why these, I don't know, again, Mormon communities in the 19th century were also encountering the very same arguments that were made to LGBT people. So there was just a bunch of scholarship, a bunch of intuitions that did not make sense. And I think continue to not make full sense, but we do have now the vocabulary, what Adrian was talking about. We do have the words, we do have some underpinnings to start from. Like, I think it was an excellent point that Robin was making about, I want to know if this friendship is something that's just fraud. That's an excellent point. That would bring us back to Ayelet and Noe's chapter about what would be the potential alternatives to marriage. So because maybe contracts are not enough, like it was happening in Missouri, Alabama, we cannot have contracts because we will not answer the top questions. So what about all these legal benefits, specifically public law benefits? You cannot be touched in public benefit or contract. So we do have to ask this question to write the next book about, and so what? Right. So I feel like it's just the very beginning of the conversation. And you're right, there's not much for me. I feel like we're proud of it.
Yeah.
You should be.
Let me just add something. When I was reading the last chapter by Professor Jeffrey Redding, I came across a common thread between religious and queer rights that I thought was very interesting and that resonated with me, which was this idea of it's a concern of the privatization of identity in community and politics. And what I thought was interesting was thinking that minority religions, rituals, practices, community, having, for example, like more extended families, intergenerational families, polygamy, are all ways of being, in a sense, I don't want to say anti-capitalist, but anti-liberalist in the economic sense. So, and queer people, what queer people do that other non-queer communities don't do is maybe they try to fight for this community that exists outside of what is seen as normal, as for example, the question of friends also ties to that. Why only couples that can make children? Why not just friends that can support each other without, purchasing things or just being friends and relying on friends for fun, not relying on other material.
Yeah, so I just want to maybe use that as that's an excellent, question and narrowing in on something that I actually think is really important, and maybe I just sort of throw it back to the audience. I'm not someone who's actually super pessimistic about the times that we live in, believe it or not. I think that for a long time, especially in the United States, people on the left and people on the right, Americans, have the perceived luxury of not engaging in politics, right? So, you could buy your car, or buy, one of the 15 varietals of tomatoes, or, engage in this, hyper-consumerist society, and it was a different struggle for different people, but but that was the American dream, right? Like you just had to work hard and you'd be able to grab all these things. And the political struggles and sacrifices that had allowed, in some sense, that luxury of capitalism just remained under-examined. And now people realize that there's a politics, and I think people are afraid. They're not accustomed to this, and they're having to talk to neighbors. They're having to canvass. They're having to vote. They're having to debate, take chances, and so forth. And so I think that there's something to be, there's something exciting and bold making that's happening in this collective behavior. And so that's like the concern about privatization of identity and so forth. That's sometimes where that line in that chapter is coming from. And I think, again, queer and religious people really understand the importance of community. And so I realized that a lot of regular people aren't really excited by this, or are frightened by this new politics, but this new needing to canvass, this new needing to talk to your neighbors, all these sorts of things. But queer and religious people have been engaging in communion, sexual or religious, for a long time now. So I just end there.
Yeah, I was referring exactly to that question. It's this fear of not having anything else. So society and heteronormative society, the pleasures that it can give us can only get us so far. And so I think the concept of family being changed, I think it can foster more community in the sense, for example, in terms of the questions of prioritizing friendship. Friendship is very not put in the forefront. Okay, so yeah, it's just Exactly
I
that.
just realized it's 6:45. 1 hour after the end of
Does anyone have questions also?
No, it's just people, and then they have to leave.
Bye-bye. Okay, I think we can close, yeah?
Yes, again, I want to thank the audience and I want to thank our authors and the.
Thank you.
Yeah, thank you. Yeah.
No, I have.